Good afternoon, all. Thank you very much for joining this webinar on the impact of the pandemic on the justice system and the legal profession. Thank you very much for joining. I hope this webinar will be interesting for you. Perhaps before we start, a little bit of housekeeping. May I, apart from the panel, of course, may I ask you to switch off your camera and mute yourself so that there is as little feedback as possible. And perhaps a little bit about the structure of the webinar and how it's going to work. It will be possible to ask questions throughout the webinar, and I'll pick up on them as we go along, and you'll be able to ask your questions in the chat. So please feel free to ask them throughout the webinar. Welcome once again to this webinar, which is organized by the Brussels office of the UK Law Societies. Our office represents three UK law societies: England and Wales, Scotland and Northern Ireland, and we are also members of the Council of Bars and Law Societies of Europe, whose representative is with us today as well. We decided to organize this webinar to discuss a very important issue, and that is how the pandemic has impacted on the justice system and the work of lawyers. The pandemic has had a giant impact on about every area of social, economic, and political life. And its impact on the legal profession and the justice system has been great as well. And it uncovered good and bad things as well. It has created some opportunities, it accelerated the existing trends, but it hasn't been without its challenges. And today's meeting will be a very good opportunity actually to briefly map that impact, to set the scene briefly, and then move on to the responses that the profession has employed, the support that the professional bodies have been providing to their members, and their role in actually bringing these concerns to the public eye, really, and to the attention of policymakers. So then quickly to move on to the future outlook and to reflect on possible future trends and how the pandemic has impacted those. And to do this, we have invited a great panel of experts, the senior office holders of three UK law societies and the representative of the CCBE as well. And without further ado, perhaps I will leave it to them to introduce themselves and to quickly outline their perspective on the topic. Stephanie, may I start with you?
So thank you very much, Anna. I'm Stephanie Boyce, and I'm the president of the Law Society of England and Wales. So I think it's fair to say that one of the most serious consequences of the pandemic was its impact on the backlogs within our courts. And backlogs were already a significant problem prior to the pandemic, but social distancing measures have made them significantly worse. And the situation is even more so severe and could take years to resolve. Outstanding cases in the Crown Court are up by 45%, while cases in the magistrates' courts are up by 21%. The time taken to complete cases has also substantially increased, with some trials being listed for 2023. And obviously that presents a number of challenges and concerns in respect of access to justice.
Thank you very much. That indeed sounds like a worrying trend. Ken, may I move on to you?
Yes, thanks very much, Anne, and good afternoon to you all. Taking the words from my immediate past president of the Law Society of Scotland, this has all been pretty rubbish. It's been pretty rubbish in so many levels for so many people, whether it's the solicitors who've not been able to work, whether it's the solicitors who've had to continue working, whether it's the law students who've been trying to do their final studies for the degree, or indeed the young solicitors or trainees who've been trying to find their feet in the legal world, or indeed whether it's the client who's awaiting their criminal or their civil case coming to an evidential hearing. It's fair to say that despite the fears about keeping everybody well, ultimately there was a response in Scotland, which has meant that jury trials are back up and running, summary criminal trials are back up and running, and the civil justice process has been continued. The question really is how we progress from that and how we operate in a future model. so as to make sure, in essence, that we learn the lessons of the use of technology without diluting the good reasons why there were ways in which we used to do things. I was giving evidence before a Scottish Parliament Justice Committee this morning, and there's a real tension between trying to get on, trying to clear the backlog, trying to use technology at every turn, but actually to say, hold on a minute, there are certain absolutes in the justice system which should not be sacrificed for convenience. And certainly at the moment, the Law Society of Scotland is trying to engage with anyone who will engage with us in order that these messages can be taken on.
Thank you very much, Ken. Perhaps I can move on to you, Suzanne.
Good afternoon, everybody. I'm Suzanne Rice. I'm Senior Vice President of the Law Society of Northern Ireland. I'm delighted to be invited onto this esteemed panel, but my main focus is going to be looking more at lessons learned and the problem-solving techniques that we came up with within our various different jurisdictions to see what worked and what we can moving forward. I have no doubt that we will have commonality across the board in terms of the challenges we've all faced in our various jurisdictions with regards to COVID-19. But I hope today will be a very worthwhile discussion to look at what we can retain and what has worked well. Within the Law Society of Northern Ireland, we have spent a considerable period of time engaging with all of our stakeholders in the justice system to ensure that we had a transition which allowed access to justice in what were very unusual times. I wouldn't say that we have the perfect model, but we certainly have been able to retain a degree of access to justice, which I think, looking back, we really should take credit for. And certainly, I think it is a good framework for us to work on moving forward.
Thank you very much. Jiří, may I move on to you?
Yes, thank you, Anna. Well, good afternoon, everybody. As Anna said, that well, I'm representing the CCBE here, and in fact, I'm chairing the IT Law Committee, and so it shouldn't be a surprise that from my perspective, and also from the perspective of the IT Law Committee, but at CCBE itself, we have tried to look at the whole COVID-19 pandemic from the perspective of the future, and the future lies within the digitalization, not just of justice, but also of the legal profession. And again, it showed that without digitalization, we would not be able to go through all the lockdowns and all the situations that we had to face. And in fact, the views of CCBE in this respect are, it seems to me, quite aligned with the views of the European Commission, whose plan in the near future is towards digitalization of justice. Mm-hmm. So I think that's our future, and we will get to that later today during the discussion. But that's the lesson learned.
Thank you very much for the introductions and for already flagging up some very important issues. Last but not least, I'll introduce myself. My name is Anadros, and I'm the policy advisor with Law Society's Brussels office, and I will be moderating today's event. And from what you already said, I mean, there's a wealth of aspects that we can look at during this discussion. And what I'm hearing, it's like maybe 3 or 4 areas that emerge already right now, and that is the work of lawyers, like within law firms, within, in-house. It's work of and with the courts, and the impact on the pandemic that actually we could see on courts, and this is what Stephanie mentioned with the backlogs. But also work of lawyers with the courts and how they communicate, and how do lawyers work with their clients. There are also a couple of other aspects, such as, and this is what Ken mentioned, about certain absolutes in the justice system that has to be respected, and I think we will come back to that issue when we discuss the use of technology and the challenges that come with. So perhaps to start us off, I'll have a question to to the entire panel about what have you observed as the most serious impact on the work of courts. And of course, Stephanie already mentioned the backlogs, but I'm just throwing the question at other panelists and asking about what have you observed.
Anna, I'll go first then, if that's helpful. I come to this experience with COVID-19 not just as a senior vice president, but also as a family law practitioner. And so one of the serious impacts that we noticed in the family law profession was the quick access to courts for emergency applications. We noticed an increase in rise in non-molestation proceedings, but really being able to have the facility to have hearings heard remotely, where your client isn't physically able to come into your office to give evidence on oath, where they're not physically able to sign affidavits, was a tremendous challenge in the first couple of months of COVID-19. In our jurisdiction, we were able to collaborate very quickly with not just our judiciary, but also our court service, whereby it was recognised early on that there needs to be a procedural change to how those emergency applications can be brought. And as a result, we did see what would be deemed to be a relaxation of some of our rules and procedures, simply because of the unique times that we are in. What that has resulted in, I have to say, is a more efficient system now in terms of the hearing and granting of emergency orders. You will now have an application heard within the day that it has been lodged, simply because our judges are now hearing and determining those decisions on the papers. And in a way, then it has allowed quicker access, believe it or not, to those protection orders than what would have necessarily been the case pre-COVID. The other serious impact that we've noticed in our profession is really the impact within solicitor firms themselves, having to deal now with workforce issues which we never would have had to, such as GDPR, matters around colleagues that have to self-isolate, being able to manage the flow of clients into the office, being assured at all times that any remote courts that we are engaged in, that they are confidential. And that really has seen somewhat of a sea change in terms of attitude, not just through the solicitors profession, but also through members of the public. It's very hard, I think we all recognise this, that in the last 18 months, our lives did move to socialising remotely through the likes of Zoom and Microsoft Teams. And for members of the public who then are using the same facility to log on by way of a remote court hearing, sometimes the importance and significance of the hearing has been lost a little bit, as members of the public haven't really adapted well, perhaps, to the remote hearing facility. And that's one of the things that we have noticed in our profession, is the concern around loss of humanity. There is an efficiency now with remote hearings, but at the same time that personal interaction has gone. And that's something that certainly in terms of a serious impact, whilst justice has to be done, it has to be seen to be done at the same time. And that is a key message that we need to work on moving forward.
That's a very important point, and I think that tension between efficiency and the human face of the system, I think it will come up in the discussion later on when we talk about the use of technology. Ken, would you have anything to add at this stage, because you already started outlining the solutions in Scotland and the problems?
Well, it's likely, I think, as panel members, we're going to tend to agree with each other in relation to the common experiences, and that's in its own way very reassuring. My office in Stirling in central Scotland is literally across the road from Stirling Sheriff Court, which deals with a broad range of business, and in fact, as of this week, has High Court proceedings starting, because we've got a lovely, large, grand county town type room that they can occupy. But that court simply closed at the stage of lockdown. So people who are expecting their child welfare hearings to deal with the merits of contact and residence, people who are expecting their loved ones or their enemies to appear from custody in relation to a new allegation of crime, or people who were expecting to answer a complaint or go to trial in relation to that complaint, the doors were simply locked to them. In a local arrangement, initially we used one of the 4 or 5 courts in our sheriffdom to accommodate all of the custodies. So although there were no business going through one court, you had a great number of solicitors standing about in rooms, standing about in corridors, actually in the court, dealing one at a time with the disparate people who are appearing from different jurisdictions. That has been altered, and one of the solutions that we have with that is in relation to virtual custody appearances. So now in Stirling, Falkirk and Alloa jurisdictions, which is a big pocket of the Central Belt in Scotland, you appear virtually on camera from Falkirk Police Office, having had the opportunity to consult with your solicitor as many times as hopefully you should need, your solicitor having had the opportunity to interact with the Crown to see if the case can resolve, and if not, to deal with the question of bail. And that may well be more of a solution when we come to talk about solutions, but that seems to work. And although it's a very substantive hearing, it's also very much a procedural rather than an evidential hearing. And as long as the communication areas are good, then that works incredibly well. From the civil point of view, again, it was really difficult to furlough my staff, be the only one who was in the office and not able to use the court. But the fact we were able to submit documents electronically was a huge benefit. We could then have hearings, initially by telephone, ultimately thereafter by video conference, and we could try and get things back on the roll. Suzanne makes an excellent point in relation to the engagement of clients with the court process. And that's still a difficulty, and a difficulty which has to be addressed, or the backlog will never be addressed, because lots of practice notes come out from the judiciary telling us how we should operate. If you operate amongst a number of sheriffdoms in Scotland, as my office does, you often just waited a couple of days to see if there was another one that would just change. What's the point of reading this one today if there's going to be another one tomorrow? And you're getting them coming in from various angles. Some of them spoke about parties as if the solicitors were parties to an action. We're not, we're representatives. And if we cannot engage in the criminal context an accused, and if we cannot have engaged and be responsive to the needs of our clients in a civil context, then we can't make progress, and the whole thing just gets slower and slower and slower. On a positive side, and Suzanne's anxious that we look for positive sides, I'm sure Jiří and Stephanie are too, there are some technological advances which we've been forced to make and which we can recognise as having been long overdue. In jury trials, we are now paneling juries remotely rather than bringing literally 60 people into a room to pick 15 plus a couple of standbys and then send others away. Why we haven't done that before, nobody knows. That's something that obviously has to stay. We were actually reasonably quick in setting up remote juries in Scotland. That was a recommendation that came from one of the members on our criminal law committee who was engaged with the Scottish Courts and Tribunal Service. That is a system which is working well. We're actually running more High Court trials at the moment than we were pre-pandemic, but it's not something that can last forever, not least because it's incredibly expensive. And again, if something goes wrong in these remote circumstances, or if you've got a technological problem, and I'll not have been the only one who had difficulty finding my link to sign in this afternoon, these things matter, and they are steps in process that we didn't have before, that if we don't make sure we get them right and they are robust, we'll not really be able to move forward. But I'm certainly in favour of identifying the technology that works and moving forward with it.
Thank you very much, Ken. Stephanie, before I move to you, Jiří, Stephanie, would you have anything to add with regard to your comments that you made at the beginning about the work of courts and the impact of the pandemic?
Well, absolutely, and thank you very much. I mean, it's fair to say that all parts of the legal system have been adversely affected by the pandemic. And to take the example that I gave earlier around criminal cases, the backlog with outstanding cases has meant that victims are waiting years for justice, and in some instances has resulted in them giving up on the justice system. So in addition, as time passes, memories fade, meaning witnesses will not be able to give such strong evidence, which can make the difference between conviction and acquittal. And for many defendants, an unknown proportion of whom are innocent, their lives are on hold. and significantly disrupted. So another area of the legal profession that has been hit particularly hard has been those practitioners who provide legal aid advice, and they face increasing workloads of open cases, which is starting to raise questions about capacity to complete their backlogs. And if I may, the official legal aid statistics show that Crown Court legal aid expenditure is down 28%, despite the measures the Legal Aid Agency has introduced to increase payments that firms were entitled to. And this demonstrates the scale of the financial impact on hard-pressed firms, legal aid practitioners. And while the furlough scheme has undoubtedly helped firms to survive, it will invariably mean that they will not be able to survive that long after the furlough scheme ends. So, you know, unless something major changes, some major changes happen very quickly, this is a real concern. And just picking up the point about technology and working remotely, invariably or inevitably, some individuals struggle with accessing or using digital technology and the capacity for these people to access justice. And we've spoken about digital barriers, geographical barriers, you know, huge swathes of parts of England and Wales that remain unconnected, or those who are unable to provide or to afford, if you like, the hardware, the infrastructure in which they need to be able to access remote provision of legal services. And the Law Society has long argued that people should not be left behind by the move to remote technologies, and that when safe, people who need it should be able to access legal support in person. Thank you.
Thank you very much, Stephanie. This is a very important point, and this is something that has appeared in other discussion and publications on the impact of COVID on various areas of life, and in here is no different, that the technology actually may create a new type of inequality, and that is inequality in accessing and being also skilled in accessing technology, because you may have an internet, you may have a phone, but you may not know how the app works, or to pick up on the example of some of my older members of family. Jiří, if I can turn to you right now, I think you probably by now we've heard quite a lot already, and I have the question I have for you: does that sound familiar, and what do you hear from the European colleagues?
Yes, I mean, everything that I've just heard is something that I could sign, that I have experienced myself. I'm also a Czech practicing lawyer, so going to courts in criminal cases, but also in civil cases. That's my daily bread, as we say. And from this perspective, I could see in person how the lockdowns, what were the consequences of the lockdowns that we have had here in the Czech Republic on the courts and on all the proceedings that were to take place. And so during the lockdowns, I'd say majority of the cases has been adjourned or suspended. The courts only heard cases, let's say in family cases where the nature really requires fast access to justice, or in criminal cases, especially in cases where the accused are in detention and so on. So the courts didn't stop. They did close the door, but just partially. Of course, there were measures that were taken by the court service that need to be followed, face masks and so on. But the courts tried to work in an extent that was still possible. Of course, it created some backlog in cases which just didn't or in which it was not possible to hear them during the lockdowns. But I don't think it was such a great problem at the end of the day. Everybody feared what would happen after the lockdown. Everybody feared that there would be no holidays, no vacation time. That everybody would have to go to courts even more often. But it was not really the case. So it seems that we managed to solve this. What helped, for example, in the pre-trial detention cases or the detention hearings, court hearings, is that even before the pandemic, majority of the hearings were held via video conference tools from prison to the court, so that this basically continued. What also created a problem is not just the working of the courts, but also access of lawyers to their clients in prisons, which is directly connected to hearing of their criminal cases, because the lawyer needs to discuss the case with their clients, and it was not possible to do it in person or only with very limited access. So what the prison service did in cooperation with the Czech Bar Association is that we managed to start up a video conferencing system for the lawyers and their clients in the prisons. And actually, this system was very well welcomed by the lawyers and is still in work until now. And hopefully it will continue to be working. So the majority of the consequences come from the lockdown period, which we, well, maybe luckily had only 2 here, but also, and that's something that is up to today, the working of the courts is different. We have to wear a face mask during most of the hearings, which, as you can imagine, is a bit harder to try to persuade the court and to give a speech with your face mask on. It's more complicated to breathe and so on, but it allows the courts to work. And I think that the situation is in a way similar throughout Europe. That's why in the beginning I said this is something that I heard, and that's something I can sign up for. And in some member states, the situation was more complicated for lawyers. In some, it was similar as to what I just described. Everybody tried to fight the war with COVID in a little bit different way. But at the end, it seems to me that all the ways basically are slowly aligning. And if I use a just a comparison with the out of justice systems world, then we all have COVID passes now, which allow us to travel and so on. So it's again, it seems that Europe is again allowing, or is the workforce behind the possibility again to work in a almost in a usual life as it was before.
Thank you very much. I mean, this was a very interesting overview of the key issues affecting the legal profession, especially the work of the courts, and the impact that it has not only on lawyers but also on clients. And Stephanie mentioned something important, that people's lives are put on hold, and also the fact that the courts have started working in different ways, and even if they might work slower than before. I have a first question from the participants, and the question is from Rita, from my colleague Rita. Can the panelists envisage situations when the use of technology could be used as a reason for claims the procedure was in breach of fundamental rights of the parties?
Certainly. And in fact, I'm aware of one such example that arises from the pilot of the virtual courts that I told you about. And that's simply the idea that not engaging face-to-face with a client inevitably means that there is distance between you. There's distance not only physically, but there's also potentially a distance in relation to the thought process. And I'm aware of at least one case where an accused was put through court, instructed a plea of guilty. The plea of guilty was tendered. The case was then deferred for the purposes of obtaining pre-sentence reports, and the accused said, that's not what I wanted to admit to. Now, there are all sorts of questions that arise there, but in that context, it may well be that it would have been far easier for the solicitor to answer their position in robustly taking instructions and relaying those instructions to the court had they actually been in a position to meet with somebody face to face. Now, I suppose as we have these examples and as the word spreads around the bar, as it inevitably does, then perhaps work practices will change and you will take steps to make sure that you are robust is as good a term as any in relation to the advice tendered, the instructions received, and the way in which that position is then relayed to the court. For the avoidance of doubt, in Scotland, when anybody pleads guilty to anything, the plea has to be confirmed, and in the sheriff court, that's done directly by the sheriff asking the accused what the position is. But it doesn't mean that there won't be wriggle room at a later stage for somebody to say, I didn't understand, I was getting that wrong. And whatever complaints can be made in relation to technology, that certainly gives wriggle room that might not have been there before.
Thank you very much.
And I can really add to that right away. And this is something that we have been dealing with within the CCBE. And I can refer you to our guidance on the use of remote working tools by lawyers and remote court proceedings. And this is exactly something in which we identified the different issues that there might arise when using remote hearing tools or just remote hearings in general. And there are questions such as professional secrecy or legal professional privilege that needs to be adhered to. And so how you do make sure that the lawyer can discuss the case with his clients. I mean, if they sit next to each other, it's easy. But if the lawyer is sitting in the courtroom and the client is somewhere away, or vice versa, that can be a problem. The issue of interpretation can be complicated. Also, other technical aspects. What would happen if there is a bad connection, and so on. So yes, there can be the video conferencing hearing can be challenged, I'm sure, and it can be also due to its technical nature. But on the other hand, I can give you an example of my own case, a criminal case where the accused was residing in somewhere in UK, I believe in London, and he was supposed to come to a court hearing in Prague, which was virtually impossible to arrange due to all the lockdown measures. And it was only due to the video conferencing tools that we managed to hear the case and finish the case. Otherwise, quite likely the client would have to be extradited to the Czech Republic and so on, which would of course be a lot more expensive for the justice systems, but also would be very complicated for his private life.
Mm-hmm. Does anyone else of the panel would like to answer the question or would have anything to add? Suzanne?
Certainly, my thoughts on it are simply that I think hearing the interaction between Ken and Jiří in terms of experiences, what kind of jumps out at me is that I think we have to get to the point where technology is not the savior of the justice system in one sense of the word. It's not going to cure all the ills that COVID-19 has triggered in terms of access to justice. And really, what we need to be looking at now is more of a blended model. So in our own jurisdiction in Northern Ireland, the Article 6 right to a fair hearing has been a real challenge in a number of both our civil and criminal cases, because as Jiří has outlined, gone are the days where your client is behind you in court, and you can turn around and ask them to clarify a matter, or if there's further instructions that you need to take. During the lockdown period, when we were running reviews and hearings remotely and exclusively remotely, we were having to come up with unique methods to get clients instructions where both the solicitor and the client were linking in remotely, and that would be through such devices as text messages, emails, or WhatsApp. But how can you get across the human interaction in a text message or in a 2-line email, and how can you do it in real time as well when you have a court that's running? So by and large in Northern Ireland, we came up with, in consultation with the judiciary, a very clear practice direction, which is where the preference is that for remote courts, it would be predominantly reviews where essentially it's more the housekeeping administrative side of the case that's being dealt remotely. Where a case requires direct evidence, and in particular cross-examination, that there would be an inclination towards an in-person hearing. And that's because, with the best will in the world, technology is not going to replicate that courtroom experience. And certainly our judiciary talk often about seeing the whites of people's eyes, seeing the emotions that go around being physically in a courtroom, and really then getting the experience of being able to properly test the credibility of witnesses, properly interrogate the evidence, all of which can become very cumbersome and very difficult if being done remotely. So in Northern Ireland at the minute, we're operating this blended or hybrid model, as we refer to, where the decision for an in-person hearing at this point in time rests with the practitioners. We will request the in-person hearing to the judiciary, and only in exceptional circumstances would the judiciary decline. What the impact, though, that has is that if you do require an in-person hearing, given the restrictions within our court building still, you are looking at a delay in terms of that hearing taking place. But that provokes another question or commentary, which is, is justice delayed, justice denied in certain cases? Is it better to delay a case to have a full in-person hearing, or is it better to proceed with a remote hearing whereby, as I've said, there are clearly evidential issues cropping up, and that could then tip into real access to justice, rights to a fair hearing, and then the consequences that flow from that if that balance has been tipped against the rights of the individual in the court participation.
Thank you very much, Suzanne. Stephanie, would you like to comment or react to what was mentioned?
Well, I mean, the only thing I would like to add is that the Law Society produced a report titled "Lawyers Under Lockdown," and I was trying to look for the link to post it in the box. But much of what has been said amongst colleagues is exactly what we found at the very start of the pandemic. And that is the concern, here in England and Wales, the current bill that's making its way through Parliament, the police crime and sentencing courts bill that talks about remote observations, that speaks of remote juries. Our concerns around those, of course, is that whilst we're told that these provisions, if they're successful, will remain on the statute book just in case. But of course, there are concerns with anything that sits on our statute books just in case. But also, there is, an element of, if we do move to remote observations, remote juries, there is an element of public legal education, a discussion around that needs to be had, where we have heard stories of individuals who have been found in contempt of court because they've been streamlining proceedings on social media, and it's educating, I guess, the public in terms of the do's and the don'ts of remote observations, and just picking up on some of the things that you said, Suzanne. is about, how do we secure the integrity of those remote hearings? So lots of questions remain up in the air and unanswered.
And Anna, it may be self-evident, but it's worth emphasising that in relation to all of these novel approaches to business, ultimately the responsibility for making sure that justice is served is likely to rest with the individual practitioner, because it will be our responsibility to wave the flag or press the button to call out something which is not going as it should, and it will undoubtedly be the practitioner who's first in the firing line if the client decides that something should have gone differently.
Absolutely, Ken. And if I can echo that added burden, so to speak, that's falling on to the solicitor's shoulders in Northern Ireland at the minute. There is a tendency amongst our judiciary to now request that clients present physically in the solicitor's office when they're giving any direct evidence. And the difficulty then becomes not only COVID compliance within the solicitor's office and the protection of staff, but also ensuring that there is space and privacy for that client in a solicitor's office. Solicitors' offices were never designed to be default courtrooms, but unfortunately with COVID, and then particularly in our jurisdiction at the minute in Northern Ireland, there is becoming a tendency to put that pressure onto solicitors' offices. At the minute, if you have a client who is due to be sentenced, they will be asked to attend at the solicitor's office and effectively be in the custody of the solicitor until the sentencing occurs. If the client is then given a custodial sentence, then there is an expectation that the client will present themselves at the nearest police station within a time period. Certainly in the early stages of COVID lockdown, there was an expectation, erroneously I have to say, that in some way the solicitor was to facilitate the transport of the client to the police station. Thankfully, with the great work of the Criminal Law Committee in our society, we were able to have that matter rectified. But that's just, an example of the practical difficulties that arise, whereby, yes, there is this desire and need absolute to ensure that there is fairness in any court proceedings, but at the same time, the tension then that rests when that burden is put on to a solicitor, both individually and in terms of the solicitor's practice, that is a conflict, as I see, which we will have to manage as we move forward into the new world of work, so to speak.
Thank you very much. I think what you were saying, and this is something that the kind of will direct me to my next question, because I will ask you about the use of technology and the most important solutions that were employed during the pandemic. But it strikes me that obviously the in many countries lockdown came quite quickly, quite suddenly. And of course, a sudden change like that requires sudden changes in law and regulatory environment. And I just want to stop a little bit on that, because of course you can start using technology, you can reorganize the way of work, but a lot of you have touched upon the fundamental problems of administration of justice and how to adapt these, and how did that look like in each of your jurisdictions. I'm wondering if you could shed a bit more light on what kind of laws and changes to the professional rules on how they are exercised have needed to happen in a very short time. I don't know who would like to start. It's a complicated question, I know.
I'm happy to jump in, Anna. I suppose what I can say is that obviously we had the coronavirus legislation, which was UK-wide, and that really became the framework within which then we looked to see on a regulatory basis and in terms of practice directions what the court service and the solicitor's profession could draft and could work with to complement what was a very changed environment, and it felt that it changed overnight in terms of its speed. What we did in the Law Society of Northern Ireland was we convened through our various committees work which was done very quickly to identify what we call practice directions and guidance, and really to give a steer to the judiciary as to what the impact meant for solicitors in practice, and where we were requiring assistance from the judiciary in order to keep essentially our doors open and the administration of justice running. So what we triggered were various guidance that we sent to our members, and that was guidance, for example, on how to apply for emergency applications, and it was very detailed advice, even down to the basics of how do you get consent from a client, what the methods of consent would be acceptable, for example, email, text message evidence. We created a pro forma document so that all practitioners were using that. We liaised with the court service to ensure that there was a way to triage quickly urgent applications, because as you will all appreciate, in the early stages of the lockdown, everything effectively felt as if it moved to email only, and therefore to ensure that the court service could identify the most urgent of cases, there was a pro forma template which was circulated. That process was met with huge success, I have to say, within our jurisdiction, and it was a framework which was then replicated in other areas of practice. So, for example, we have what's called HR forms or FCI1 forms, which are essentially review forms that practitioners across the jurisdiction complete to allow courts to be updated, to know what the case progression is, and those reviews can then be dealt with administratively. So those were some of the steps that within the Law Society we felt at the early stages needed to be taken in collaboration with, as I said, the court service and the judiciary, which worked exceptionally well, and which we are confident will probably be one of the lasting solutions to the COVID crisis, which will remain as we hopefully transition out of COVID into a more normal working environment.
All right. Thank you very much. Anyone else on the panel would like to comment on this or answer the question?
Last March seems a very, very long time ago. The number of changes and the rapidity of the changes was simply mind-boggling. The Law Society itself, our offices closed, everyone went to remote working, some solicitors' offices closed, the courts were closing, there was various practice notes outstanding, the registers of Scotland closed, so if you were thinking of buying or selling a house, you could forget that. What the Law Society did was it tried to engage with everyone that it had to get things open again, or if not operating. And there had already been mentioned by Suzanne about the question of remotely swearing documents. There was guidance changed in relation to the remote notarizing of affidavits in particular. It was just a mind-boggling time of change. I mentioned already the question of practice notes within courts and how difficult it could be. Each sheriff principal in our 6 sheriffdoms had their own ideas, and rightly so. Hopefully they were local and specific and very well intentioned, I have no doubt, but it certainly led to complications. The difficulty really was to try and just keep everything operating as far as we could and get on with it, to support the profession, to try and make sure that there was still contacts in the Law Society offices from a professional practice point of view, from a well-being point of view, as the initial 4-week lockdown turned into 4 months, 14 months, and then continued. It was a mind-boggling operation, but I would have to say that there was goodwill and good ideas coming from very many directions. And to the extent to which the Law Society of Scotland was allowed to participate, I think we achieved better outcomes than otherwise would have been the case.
Thank you very much. Maybe Jiří or Stephanie, would you like to comment?
Well, it's hard to comment from the CCBE point of view on the regulatory challenges, because CCBE usually works on the EU level, but the whole pandemic time showed how important it is to have proper regulation that would also regulate these particulars of everyday life and working of justice. And So during the pandemic, we have been quite actively working on the revision of the taking of evidence and service of documents regulations that come from the European Commission. We have been commenting on the artificial intelligence proposals that came not just from the European Commission, but also from the Council of Europe and the High Commission, and whole other aspects of digitalization of the European justice, including, for example, the e-codex. So many of these regulations and legislative proposals come from the times before the pandemic, but we could see how the whole pandemic showed the importance of the digital approach to justice.
And this is a good moment to ask you the question that came from Rita already some time ago. Do you know if there are any plans by the Commission to coordinate the digitization of justice systems?
Yes.
That's a short answer.
So there's the European Commission has come up with the e-justice action plan, which includes many different topics of or ways to digitalize the provision of justice in Europe. AI is or the wider use and regulation of AI is just one of them, for example.
Thank you very much. That's certainly something that we will pick up on a little later today. But Stephanie, I'd like to give you the opportunity to comment on what was just said.
I mean, absolutely. Firstly, can I say that Rita has kindly put the link in the chat in respect of the report that I mentioned earlier, and it's actually called Law Under Lockdown, not Lawyers Under Lockdown, as I incorrectly stated earlier. But of course, you know, technology has, you know, we've seen the way that technology has transformed the solicitor profession, certainly in England and Wales. And we jokingly have said that it was able to do in 48 hours what perhaps would have taken 10 years to do. And that has absolutely changed the way that we have worked. And there are positives and negatives, and we've spoken much about those already. But it goes back to, in my mind, it goes back to one thing, and that's about the ability of individuals to be able to access.
You can hear the.
That goes back to the ability of clients, individuals, to be able to access justice, and that they shouldn't be excluded from justice, being able to access justice because of all the issues that we've identified, whether that's financial or those are resources. And, you know, additionally, it's important that from a practitioner perspective, that again, for the reasons that we've mentioned, that they are able to receive full instructions during a hearing, leading up to a hearing, so that their clients understand the implications of the decisions that are being made. And that, we say, can be difficult to guarantee in remote hearings. So we've seen how technology works. There's a number of, and the other thing the Law Society has been doing is seeking to get assurances from government around, you know, if IT fails, and Ken mentioned earlier about the difficulties he was having connecting. I'm enjoying quite a stable network connection at the moment. In fact, I have to say that it's far better than when I'm in the UK currently. But you know, the reality is there are still huge swathes of citizens in England and Wales who do not have stable internet connection, who don't have broadband internet connection, full stop. And so those individuals must not be left behind. And one of the issues, the concerns that we have is getting government to try and guarantee that there are alternatives in place should IT failures happen, and we know they happen.
Thank you very much, Stephanie.
If I might just very briefly comment to that, Stephanie, I completely agree with what you just said, but also I think we are speaking about digitalization of justice and remote hearings and so on, but I think that it can, and I would almost say it can never happen, or it should never happen, that there will be only remote court hearings, and that's just because of what you have just said.
Thank you very much, Jiří. In fact, I actually wanted to touch upon this this aspect briefly, because we talked a lot about the work of lawyers, how courts work, but already Stephanie and Jiří mentioned the impact on clients. And I actually was wondering if as you work in professional bodies, have you heard any feedback on the impact of different categories on clients, and what solutions have been actually used to make sure that actually everyone has access to justice? Anyone?
Well, just from my own family law experience, I ran a number of cases remotely during the lockdown phases, and obviously the types of cases that I was dealing with were cases where children were being removed from the care of a parent. That's a very challenging case in itself at the best of times, and you can only imagine what it must have felt like for that parent to be on a screen in her home, watching effectively 4 or 5 other different pictures on her phone, which was essentially the remote court deciding that her child would not be coming back into her care as a result of very serious concerns. In my experience in that case, it was a fairly young mother who was very, very vulnerable. And I suppose one of the difficulties I identified very early on was that while she was physically participating in the hearing in terms of seeing what was going on and hearing what was going on, the emotional impact, the degree of her understanding, none of that could actually be assessed over a video screen. And therefore, one of the key things that we looked at within the family practitioners was where you do have a very vulnerable client, where technology isn't going to assist. If anything, it's going to exacerbate their anxieties, whether that be because they have a disability as a result of a very young age, a lack of understanding, or even such disabilities as being unable to hear, or perhaps having visual impairments. All of those issues have now been brought to the fore as a result of remote access, probably much more than we would ever have seen. So as a result, in terms of clients that present with those types of difficulties, in our jurisdiction in Northern Ireland, we are continually reminded, not only by the judiciary, but also by the Law Society, that we have to take into consideration those difficulties and that we have to make adaptations. And I've already touched on one adaptation, which is where the client is now being asked to come into a solicitor's office so that there is that human engagement, so that there's much more than just simply dealing with the case, but actually looking at the welfare of the client and making sure that the client understands and can manage whatever the outcome may be. But as I said, that's a result of having walked through that pathway and seen those difficulties as they arise. And it's very much a case of having to pick up on the lessons that we are learning. And as Jiří said, technology and remote hearings, they were never designed to completely replace what is the traditional method of attending court, attending your solicitor's office in person. So it's all about trying to get a model which works for your client as the individual, not a one-size-fits-all. And I think that's a key message, that as we move out of the COVID era and we transition into what I call a new working life, that is something that I think we have to be respectful of, and continually remind ourselves as practitioners that we have to look behind the case and look at the individual who as solicitors we are representing.
Thank you very much. Would any other members of the panel have comments at this stage, or would like to?
Yeah, I'm happy to throw something in, because before we went to virtual custodies, when I wasn't jumping in my car in Stirling and driving to Falkirk to hang about until it was my turn to put somebody through, plead them not guilty, and come back to the office without being able to claim a penny in legal aid. I was on the phone to clients in relation to contact cases, and whether I was acting for the resident parent or the non-resident parent, there was a lot of COVID madness and COVID anger going on. There was a lot of health worry. There was a lot of potentially opportunistic use of the COVID situation to say that, I'm sorry, so-and-so has been exposed this week, they can't go for contact, or they don't want to go for contact, or some other excuse. These things, I'm afraid, are simply the inevitable fallout from a lot of COVID madness and a lot of COVID anger, and those are terms I've used time and time again and will use again. The difficulty again for the practitioner is to manage that, to give the proper advice. There was in that context advice that was promulgated by the Lord President's office. There had earlier actually been advice that I think came out of the Family Law Division that before the Lord President jumped on board. I saw that online and was copying that to clients who could be given it to try and just engender some goodwill and good faith in the whole process. Sometimes that can work, sometimes it doesn't work. But taking on Stephanie's point, I've got clients who don't have mobile phones, never mind don't have Wi-Fi. So you've got to be careful how far you march on technology and what kind of assumptions you make.
Thank you very much. Those are all very important points, especially and this is what we touched upon before as well. I mean, you can have access to internet, but you may not understand the procedure, you may not understand what's going on, and actually you may not also only know that you can ask questions about some of those procedural aspects, and you can question some of the practices, for example. There is a comment in the chat, and that comment is about digitization of the civil proceedings in Italy that are working very, very well. And there's more comments, but I'll stay on the first one, Antonello, if I may. Antonello is a practitioner in mediation and arbitration, and at this stage, I'd like to ask you whether you observed the use of other forms of dispute resolution due to the problems in courts and also due to the backlogs.
It's me, Anna.
Yes.
Oh, yeah. Thank you for the attention. No, it's just to say that this is a new frontier to remove also barriers for gender equality in the access to the profession for women, for example, because more often the colleagues are engaged with family issues. So it's very important for me. Very important. In Italy, works very, very well. And I hope that also in the UK, the digitalization of the proceedings will go ahead. Also because we used to sign and certify documents with certified signature. It's another very fruitful and useful tool. No.
Thank you very much.
My pleasure.
Thank you. The question to the panel: Would you actually see other ways of resolving disputes, partly as a result of COVID, but also as a general trend of having some disputes online, something that already happened in some areas? And I'm just wondering about the panel's views on that particular trend, and has it been impacted by COVID, or has it been accelerated?
I suppose in Northern Ireland, we noticed early on in our civil jurisdiction that where the courts were slower in our civil division to effectively change their modus operandi in terms of practice and procedure, practitioners then turned to more mediation, more negotiation, and there was more settlements outside of court where possible, simply because run-of-the-mill RTA cases, for example, would have taken many months before they saw a courtroom for any type of resolution. So there were pockets of opportunity where justice was served quicker, and that was through alternative dispute resolution forums, and certainly in terms of mediation, moving to remote mediation also worked very well, particularly for clients who would have been out of the jurisdiction, and trying to get everybody in a court building at the same time for a traditional consultation, joint consultation with regards to a settlement, traditionally would have proved to be quite problematic. So I suppose what I would say in terms of the experiences of practitioners in Northern Ireland was that there were some improvements and some attempts to effectively think outside the box, to bring cases to a speedy conclusion. And that's touching on really what Stephanie was alluding to earlier on when she talked about, you know, the impact, particularly for legal aid practitioners, where the court system becomes sluggish and cases can't be processed and concluded in a realistic and reasonable time frame. Not only does the client suffer in terms of a conclusion to their legal dispute, but also the impact then on the solicitors in terms of fees coming into the office and effectively keeping the doors open for clients to receive legal advice. So certainly within Northern Ireland, when we, as Ken was talking about, the 4-week lockdown, which then became 4 months and then started to extend on, I think within Northern Ireland, we as practitioners recognised that in order to keep things moving, we did need to think outside the box. We did need to start negotiating and mediating more so perhaps than we would have done before, because the access to the court wasn't just as quick or as readily available as it had been in the past. Whilst we don't have any survey yet to show what that has now resulted in terms of alternative methods of disposal, it certainly is something I think moving forward in any COVID review that both our politicians and our governing bodies will be looking at to see where new trends have started to materialise and where we can build on those new trends in terms of alternatives to problem solving justice effectively.
Thank you. Does anyone else want to come in on this question?
Well,
Can I just? Oh,
yeah.
Go on, Jiří.
Stephanie.
No, all I was going to say is, you know, as lawyers, we are, you know, dispute resolvers. You know, I think ultimately nobody wants to end up in the courts. And, you know, there are certainly in England and Wales, there are senior members of the judiciary who are very keen on alternative dispute resolutions. But it's important, you know, whichever form is adopted, that, you know, clients, and this goes back to a certain extent, my public legal education point. It goes back to the point that clients need to be aware as to what they're signing up to, and be given the best information in order to make the best decisions that suit them. But if I can quickly just go back to the question in the chat or the comments in the chat about Italy, you know, what I would say is, and just noting what's said there, is that in many instances, technology has been more convenient, accessible, and time and cost effective for, you know, practitioners, you know, parties and judges. I think that's clear. They, you know, have minimised travel times, which has had a significant impact, where there are issues of commuting, childcare arrangements, and so forth, and also provided a better work-life balance, which has subsequently contributed to improved well-being. However, there has been a significant cost in developing online systems, and we have seen that amongst our members. It takes time and money to train lawyers, members of the judiciary, and the public on new technologies. And in addition, there have been questions about the impact, and I go back to the point as to the impact on access to justice for some clients. And we recently saw some comments on social media where individuals were complaining that whilst it's convenient for the lawyers to be, you know, doing a number of hearings from the convenience of wherever they might be doing it, it's not so convenient for the clients. And there is a growing chorus of individuals who do feel that they are not being served currently by the justice system and indeed practitioners. So we just have to be mindful of that.
Thank you very much, Stephanie. Jiří.
Yes, just to add just a slight note to that. So, of course, the alternative dispute resolutions are here and are useful even in these times. But also, I think, and the only question is how far is the future? We'll see more and more of online dispute resolutions, perhaps in the beginning, just in the small claims, maybe parking tickets cases and so on. But with the future, it will become more and more common, and also the artificial intelligence, I think, will really help to pick up online dispute resolutions in the future. Again, not in all cases, just in suitable cases. I cannot imagine, for example, a family case being decided by an artificial intelligence. But cases where the facts can be established quite easily, then it's a set of facts and now really I quote an easy application of law. So I think we will see that in the future more and more.
I am extremely envious if Jiří has cases where facts can be established very easily. That's not my experience. Stephanie's absolutely right.
The same thing.
Solicitors are problem solvers.
It's not family cases for sure. It's not criminal cases for sure.
The difficulty was that when the courts were closed, if a solicitor on one side and a solicitor on the other side couldn't resolve a family dispute, for example, between themselves, there was no one the case could be referred to. We were the ones that were working because we had to work. This goes back to a funding point that Stephanie made, and I'll make it later if I may, because I think it's quite important as a moving forward point. But we were the ones that were working because we had to work, because we couldn't be furloughed. As a principal in private practice, although my staff had furlough support, I had none. So I was in the office every day sorting out the business, not just for altruistic reasons or reasons to do with the administration of justice. I wanted to be doing some work that I could get paid for that could then support the running of my firm. But if I wasn't there, I'm afraid, subject to some third sector volunteers, there weren't very many people to whom we could refer clients. And largely, it was either sort it out amongst themselves if we couldn't sort it, or it just had to wait to be judicially determined. But you know what they say about artificial intelligence, it's 5 years away, and it always will be.
Thank you very much. Before we actually come back on, the long-term trends, which I think are in the interest of time, I'd like to move a little bit on what is there to stay. And some of you already touched upon some of the solutions that have been employed during the pandemic, and they fared quite well, and they are there to stay. I'd like to stop a little bit and look at the actual workplace where lawyers practice, and to look at law firms and wherever lawyers are as employers, and how that changed, and how and what changes will this bring in the future. I'm referring specifically to hybrid working and the dynamics in the organization, but also different professional development pathways that are potentially emerging. And I'm wondering if you had any observations on this, looking at the dynamics of your own work over the past more than 1.5 years now.
Yeah, well, I can start perhaps. So I think with the first lockdown, everybody went online, everybody went working from home, and it works for a short period of time, I would say, and I mean a few months. But then you see that when people or when lawyers don't talk to each other in the law firm, there's something missing in their work in the daily practice. So I think that with things getting back to normal life, we'll still see a lot more homeworking than we have seen before the pandemic. But on the other hand, law firms do realize the importance of working from the office the importance of the lawyers being able to communicate and discuss the case in person, not just over some video conferencing tools. Mm-hmm. So I think that's going to be the new normal.
Anyone else?
Well, so the Law Society has produced some guidance aimed particularly at junior lawyers and trainees around supervision and the good practice for remote supervision of junior lawyers and trainee solicitors, as I said. And that covers a number of areas in terms of regulatory requirements, opportunities for development, use of technology, well-being, reasonable adjustments, and so forth. But of course, what we've also seen, we've seen the push towards moving to a more hybrid model. We're told that a great portion of staff want to do at least 2-3 days a week at home. I heard somebody say the other day, who would have thought, a couple of years ago, the idea of working from home, solicitors working from home, would have happened, and indeed happened so quickly. That potentially is an impact on the way that we will train going forward. Technology we know is going to play a greater role in our work lives. But also we've seen a number of mixes in terms of hybrid working policies. There is now a conversation around, do you have policies in place that address hybrid working or agile working? But equally, there are some concerns in terms of if individuals are permitted to work in an agile way, does there need to be boundaries in terms of timing? I understand one organisation has a cap that their working hours are between 7 a.m. in the morning and 7 p.m. But equally, we've heard conversations about where the court system is sending out emails at 1 o'clock, 2 o'clock in the morning, where practitioners are required to respond or submit applications by 10 o'clock that same morning. So it's trying to address the issues that hybrid working presents. But the biggest one, I think, for me, and certainly of the conversation that I've been having over the last couple of days, as I'm attending my first in-person event since I became president, is we learn a great deal by osmosis. Those conversations around the water cooler, the coffee machine, the tea, the kettle, and it's certainly for me on a personal level. It has been difficult, and I have the resources at home, a separate room, a desk, a chair, to sit at and work, and I would like to think work effectively. But not every colleague. And we've seen and heard where individuals, some have been working from the kitchen table, ironing boards, in shared accommodation where their bedroom becomes their office, becomes, that's the only space that they're able to utilise. And it's becoming, senior members of the profession who are, it's been suggested, are potentially more in favour of working from home as opposed to the junior end of the profession. But also from a personal perspective, now if I want to talk to someone, if I have a point to make, it's you either have to set up a meeting or you have to send an email, and it's those things that take so much longer. And then you kind of think, if I was in the office, and I have been going into the office more and more because I miss that interaction. I saw my hearing suffer. I mean, strange things, as much that my hearing suffered, my eyesight has suffered because, you're not utilising those senses, you're utilising other senses, but those in particular. But the ability to have those conversations that we thrive on, human beings are social creatures, and we learn so much, subconsciously, and to have that removed, where we've seen firms, organisations shutting down their offices, or downsizing is a concern, and potentially, whether or not due consideration is being given to the future and what the future may entail, whether that's, you know, true hybrid working, or we are going to see a shift back to working in the office. And I know so many colleagues have said, you know, so glad to be back in the office. You know, once they get over that initial anxiety, but so glad to be back in the office because they've missed that interaction. And, you know, and having been at home for almost, some colleagues have been at home for almost 2 years for one reason or the other, that they have missed that. So I think we need to keep an eye on it. And as somebody said to me the other day, I'll finish on this point. Somebody said to me the other day, head of legal in a local authority, she said to me, I'm no longer a manager. I'm a well-being, you know, I'm having to manage people's well-being, you know, and the range of issues that presents, and of course the hidden ones that we haven't even yet come across that are potentially there.
Suzanne, I saw you nodding vigorously.
Yeah, no, everything Stephanie has said resonates with me greatly, I have to say, and indeed our president of our Law Society's key theme really in 2019-2020 was around the welfare of the profession. And one of the stories that I heard as I travelled along as senior vice president during the COVID era was you know, the experience of a young solicitor who suffered a very sharp rebuke from a judge in a court case that was being heard remotely. And normally when that happens, and we've all been there, we have all the stripe marks on our backs, I'm sure. Normally when that happens, you know, outside of the courtroom, you'd have a bit of collegiality, you'd have reassurances, and somebody, quite frankly, would be picking you up off the floor, dusting you off and pushing you back into the next court. But when you're working remotely, you're a young solicitor and that happens to you, who do you turn to in the room that you're in to seek that support, that moral support? Who was there to witness that, to give you that encouragement? And very often what we were hearing during lockdown was that those solicitors and junior counsel as well, when that was happening, they didn't have the skills at that point in time to be able to rationalize, to be able to process. And as a result, they were then internalizing what was perhaps for a judge a throwaway comment, but for them was then going to really erode their self-confidence. That's one of the things within the Law Society we've been very conscious to really look at now moving forward, is how we can support younger colleagues, how we can give them that, you know, virtual support, which at times that's all we've been able to do because of lockdown, but now moving towards more of a pastoral role, to be honest with you. And that is a challenge, there's no doubt about it. And it's something that we have to be mindful of moving forward. And certainly I think well-being and welfare is going to be a key message in solicitor firms as we move into 2022.
These points, Anna, are all very well made, and Suzanne's last point in particular indicates just how much we rely on the quality and the judgment of our judiciary, because that kind of thing's not fair in the best of times, but it's certainly not fair if the COVID anger gets onto the bench and it is directed to a younger, more inexperienced practitioner. Stephanie's point about emails at 2 o'clock in the morning to be responded to by 10 AM fills me with horror. I suppose there may be cases where you're expecting some judicial consideration of something overnight and they may well be looking at it the following morning. But just the immediacy of no longer having the Royal Mail, in our case, deliver the letters in the morning, the secretaries pull out the files, put the files with the letters get some sort of priority in a pile of your desk, and you work through them sometimes before, sometimes after you've been at court. Everything has to be on demand, and we have to have a way of trying to regulate that. We have to be conscious of that for ourselves and for those with whom we work. We've got to be conscious, I think, not only of the health benefits of getting people back into a social environment with colleagues, but also to be sensitive to those who perhaps have now adjusted to a working from home setup, hopefully a healthy one, hopefully one where they have some balance. Often I imagine if there are other family members who are within their living environment, and they may well say, you know what, that 4-hour commute that I used to have, I can do without it. It doesn't add to my productivity and I can still perform properly. So I don't quite have those challenges in my own office. I'm just trying to get my secretaries to come back as full-time as I possibly can have them to service the solicitors who are now all full-time in the office. As a law society, we are certainly looking at sympathetic ways of hybrid working, which makes the teamwork operate, but also allows those who are more comfortable and just as efficient working at home to be accommodated in relation to those desires as well.
Thank you very much. Jiří, would you have any comments at this stage?
Well, just as Ken mentioned, working from the kitchen, you know, and maybe just with the children running around, or you know, wife or husband just being around. There's also a question of lawyers' confidentiality, because if you're having a video call with your client discussing the case, and there's someone else, someone non-lawyer in the room hearing, you know, the case, that's a problem, I think. So, and of course, for those working from home, not having any other option but to sit in the kitchen, this is a problem.
Thank you.
Just another problem for the solicitor to manage.
And actually, Jiří, that gives me an opportunity to ask you one final question, and in the interest of time, perhaps we can finish the discussion with your views, short views on two questions. What, in your opinion, is there to stay, and where you would see the opportunities for more work that needs to be done? I'm referring to the solutions employed during COVID as a response to the challenges that you've identified today.
I said, Anna, that I would come back on the funding point that Stephanie quite properly raised, and funding is a huge issue. In the Scottish environment, following representations made to the Scottish Government in particular, we had a package of measures to help legal aid practitioners. We had a resilience fund, which was £9 million to be distributed amongst firms. Didn't work terribly well in its first round. There was only £2.3 million spent. That raised certain red faces in Edinburgh, and we're on a second round now, which the Cabinet Secretary for Justice has promised will result in a full spend. We've also had a trainee package in the legal aid sphere, and we've had some increases in fees. But there is no doubt that if legal aid is not properly funded, if those who cannot afford to pay for access to justice in the criminal or the civil sphere are not supported by elected politicians, then that is a real problem. In particular, in the criminal sphere in Scotland, underfunding for year after year means that there are now fewer people doing it. There's an older demographic. It's not attracting people to come in. And what do you do to fix that? If there is an engendered feeling that there just isn't money in that kind of work, it's not sexy anymore, it's not valued perhaps, then people won't want to do it. And in particular now, we've had a round of funding which has involved the Crown being given extra money, and as well deserved, I've no doubt, as that money is. That then means that if you're a prosecutor, you're going to be paid more at a younger age than a defender. And that means there's going to be nobody on the other side of the table. So that's point one, funding. The second point is the question of evidence. Best evidence, the taking of evidence in commission, and we spoke about that initially. It's really important if complainers and witnesses are to have their positions vindicated in an adversarial system which is seeking to establish, to overturn the presumption of innocence and to see whether guilt can be established. It is important for complainers and witnesses that they have the best shot at presenting their evidence to the court. And I wonder whether eventually someone will have to blow the whistle or wave the flag on a step too far that just removes the person who is to be believed, if the prosecution wants their case to succeed, from the decision maker who could believe them. And if a desire to, for want of a better word, mollycoddle, I don't know how that translates into Czech, but it's sort of look after, wrap up in cotton wool, and protect, almost on the basis that they are presumed to be telling the truth, and that the presumption of innocence to finding of guilt is to be something of an automatic process. That, frankly, worries me, and it's something we all have to try and guard against.
Thank you. Thank you very much. Suzanne?
Well, I'm trying to be optimistic, and certainly I think that during the COVID period, the hybrid model, the opportunity to do reviews remotely. There is no doubt that it is worth its weight in gold in terms of case progression and really making the solicitor's time much more efficient. I think I averaged out that for me to attend my local court for a 10-minute review would in turn result in really a 1.5 hour period out of the office. Now, by way of remote courts, it is simply that, a 10-minute review. That's the positive moving forward. It's going to see, I think, case progression being a lot more efficient, and in theory bringing cases to a hearing a lot quicker. As to how the actual hearing happens, that's another topic that we've already discussed. But the downside to that is the funding issue that both Ken and Stephanie have outlined, and that is when you increase the efficiency in the solicitor's practice, you are increasing the cases that we are doing on a daily basis. That means potentially longer hours working. That means new ways of having to do things. And if the hourly rate for a solicitor that is being funded by our public fund, our legal aid board, doesn't equate to a fair and reasonable remuneration, then there is going to be a significant chill factor. And younger solicitors and even older solicitors are going to move into areas of work which are going to be properly remunerated. And that means, quite frankly, that the most vulnerable in our society, the families, the criminal clients who are charged with the most serious of offences, don't necessarily or won't necessarily have the best access to justice or the most appropriate access to justice, because there's going to be a shrinkage within the profession. And we're going to, because of that funding crisis, create a brain drain within the solicitor's profession. So it's a very serious message, and I think that COVID is simply now going to highlight that even more so moving forward. And it's something that I think collectively our governments as a whole need to now recognise, that access to justice is more than simply just linking a solicitor up with a client. It's about a degree of service. It's about a standard of service. And the work that we as solicitors do is so vitally important to keeping not just the wheels of justice taking over, but keeping social stability, economic stability. And I think that global picture needs to be reinforced to all of our local governments right across the board. Otherwise, I very much do fear that the people that will suffer ultimately will be the very people that we represent on a day-to-day basis, which is the public.
Thank you very much. Stephanie.
Well, I'm not sure how I can follow that, but absolutely, both we've all spoken about the funding issue, and I'm absolutely passionate about legal rights mean absolutely nothing if you don't know when those rights are being taken away, or indeed you don't have access to be able to enforce those rights. How do we get, I think we're all agreed about the funding issue, how do we get governments to invest in the justice system? We start to get the public on side. We start to get the public thinking about the justice system before, not when they're caught up in it. And for me, that's about, again, I go back to public legal education, teaching law in schools, to get the public thinking about the justice system as a national treasure, like we do the NHS. That's how we get government to invest in our justice system, because we're not all fat cat lawyers that the media and other parts of society would like to have the public believe. But we do important work enabling individuals to be able to exercise those rights. And like Suzanne said, it's not enough to link up to link members of the public with a solicitor. They should be able to get advice and get that advice as earliest as possible.
Thank you. Jiří.
Yes, well, we've spoken a lot about digitalization, about remote communication. So if you ask me what is here to stay, I think that's remote hearings, remote court hearings, but also remote communication with the clients, be they in prisons or be they at their homes. What needs to be established, I think, is still the way the remote court hearings operate, what the best practices are, what the parties can and the lawyers can expect. How is the lawyer's confidentiality? How is it going to be assured during the hearing? How is interpretation is going to work during the hearing? What about interviewing witnesses? What about taking of other evidence and so on? And also establishing which court cases or court hearings are okay to be heard remotely and which not. So I think we are still gaining some experience on that, not just in the UK, but just also throughout Europe. And we still have some long ways to reach some established practice in this sense.
Thank you very much for all your remarks and the wealth of information and experience that you shared. I hope you took away some lessons and some conclusions that you can use in your work, just like I hope that the audience did. I'm sorry that we ran a little bit over time. I hope it was worth it. And thank you very much once again. We will be sending the materials that were in the chat once again to all those registered via emails. And if you have any questions to us later on, please send them as well. Thank you very much.
Thank you for the invitation.
Thank you. Great to see you.
Thank you.